Well, thank you, South Brunswick Library. My name is Ken Vercammen, and I enjoy talking to my friends and the people I've probably met and ran into at South Brunswick high school events, South Brunswick's grammar school events, and different soccer events. So we're talking about estate planning and how people can kind of, in a way, save money and make it easier for your family. Because the biggest thing is, people don't have wills, and the surrogate will be the first person to say, listen, let's see, if you don't have a will and you have assets, you're doing a disservice to your family. Because if you have no will, or it's not found to be valid because it was a cheap thing online that wasn't properly signed or done, a non-admissible probate. Well, number one, the procedure to distribute assets becomes much, much more complicated if there's no will. It means, like, for example, let's say there's 4 kids. All the children would have to agree who is going to be the administrator of the estate, and they would have to sign an affidavit of renunciation saying, I renounce being the executor or the administrator, and having to pay a fee to have that filed. If all of them won't sign that, then whoever wants to become the administrator has to file a complaint order show cause in a superior court, spending 3-4 grand, and they're not going to see a judge for 2, 3, sometimes 4 months. And meanwhile, nobody has any ability to do anything. I'm involved in a state right now. I'd say, grandma didn't have a will. So there's 14 different beneficiaries. And because one of them won't sign the renunciation, we have to file a complaint, order show cause, serve everyone. It just runs up fees. If someone's goal is to have it cost the family more money, that's what they're doing. Number 2, if there's not a will, or a cheap form doesn't say no bond is required, the person who becomes the administrator has to spend a couple grand on a bond. Again, usually unnecessary expenses. When there's no will, the procedure to distribute assets becomes much more complicated, and it requires an accounting at the end and other things. But more importantly, when there's no will, it often causes problems amongst the family, sometimes lawsuits. And when loved ones are grieving, there should be one more thing they have to deal with. So for people who don't have a will, think about, okay, who do you want to get your assets? Who don't you want to get your assets? Because sometimes, if you don't have a will, it wasn't your goal to give the state of New Jersey and the government more money. Of course not. Think about, okay, if someone has minor children, who do you think would be the, there's no best person to raise your kids, but who don't you want? So when I, for a lot of my South Brunswick friends, I goes, hey, I don't really have that many people in the US. I goes, well, if you don't have a will and you have minor children, one of your in-laws, in India or another country, could conceivably petition a court saying, I want to be the guardian. So it's important to have a will, and there's no reason to put things off, because we've made things much easier to do. So, for example, I mean, the old way was taking half a day off of work, driving to the attorney's office, filling out a form in the reception area. And we were lucky enough back in 2019 to convert it to try to do as many things as possible by emailing the form so people could type things up. So when COVID hit, we're still able to do most things. So again, the procedure became much easier, because what the attorneys do is we email out a short questionnaire. And believe it or not, New Jersey did away with some taxes. They did away with the New Jersey inheritance tax. If it's going to spouse, children, grandchildren, stepchildren, they did away with the estate tax. So I don't need to know a lot of details about people's assets. So, our interview form for most people's asks less than 10 questions. Anyway, so logistically, you type it up, you email it back to the attorney. The attorney does a new thing. They pick up the phone and they talk to you. Everyone says, I'd like to make an appointment to sit down and go over stuff. And I would smile and go, okay, Mr. X, let's say, are you looking to disown your wife or have everything go to her? I goes, everything to my wife. Are you looking to disown your kids, or do you want anything after that to go to your kids, to my kids? He goes, Mr. Shaw, I know what you need. you don't need to take a day off of work or half a day to come and see me. Say, and logistically, like, people can now pay online. There's a law pays portal. So if someone doesn't want to send in a check, then they can take care of doing their documents. So, okay. What are the complicated questions that people don't get a will done because it's so difficult? Okay, what's your name? Who's executor one? Who's executor two? And I tell people it's best to have a number one executor and a number two rather than joint executors, because with joint executors, it creates twice as much work. That means that two people have to do everything. Two people have to go to surrogate's office. Two people have to fill out all the papers to sell a house, and two people have to sign a deed. Two people have to sign every check. So that's why there's one president and a vice president. It's better to have an executive one and executive two. And by the way, sometimes our senior citizens say, I'm not good with computers. How can I get the will done? I goes, well, I'd say, yeah, we still see people in the office in Edison, but I go, don't you have kids or grandkids that, want to inherit money? I said to a client, I goes, I have a good idea. You haven't seen your granddaughter in a while. Tell her that you want her to come over the next 3 weeks, and you're going to give her $5,000 if she comes over and helps you fill out the form. And if any granddaughter says, no, I don't want to help you, grandma, well, that's the person should have a clause in that says nothing to them, because I asked them to help me and they were too busy for a month. They couldn't spend, an hour with, and it doesn't take an hour to fill this out. It takes for most people 15 minutes. So, and so some people, because of medical, they're not good on the computers. Okay, fine. As long as a family member can type it for them, I just need to speak to them before we actually do the documents, because under the conflicts of interest law, we have to make sure it's what they want, not what, the person who, the other family member wants. So I have to be able to talk to them. They can't talk and communicate to me. Sorry, but I can't do the documents. Basically, I either have to do it right or not at all. A gentleman's, we're doing his will. And he goes, we also need to get a will done for my dad. Okay. But he goes, he doesn't speak English that well. He only speaks Gujarati. He goes, okay, how many kids are there? There are 4. He goes, but my dad wants everything to go to me. He goes, sorry, sir, I can't do your document, because if your father can't tell me, how do I know what he's saying? I have colleagues that, speak, that language. So if someone can't actually speak to me in English, then I can't do it. Okay. Now we ask assets don't get listed in a will unless it's a specific bequest. So therefore, I really only need to know what real estate you have in New Jersey, what real estate you have somewhere else. All right. Let's say, and then I ask, are all your other assets more or less than $12,500,000? Because that's the amount for federal estate and gift tax. So maybe some of the people who live in Drinking Brook Estates have $12,500,000, but most of my friends in South Brunswick do not. Now, a will, by the way, only transfers assets that you own that don't have a direct beneficiary. Okay, certain assets pass direct, and a will can't change that. So the main example, when a house is owned husband and wife, let's say if one passes, house automatically is owned by the survivor. A will can't change that. If a bank account is payable upon death, joint tenancy, POD, automatically goes to that person. The will can't change that. Other assets pass by contract. IRA, 401k, life insurance, annuity. So it is a good idea, unless you're 1,000% sure, that you contact the companies, get a printout, and it's a rare time where we like paper, and you put it in with your will file, so that if you pass, who's ever your executor one or executor two, you have a nice little fireproof box that has your will and other things related to your estate. The reason why it's important to know about assets in other states is your number one, your will in New Jersey is valid in any other state, even if you move. But if you have real estate in another state, there's a thing called ancillary probate, where you have to go to the surrogate of that state and then get paperwork so you can act in that behalf. Some people have assets in other countries, and people says, okay, how will my assets pass in the other country? And my honest answer is, I don't know, because I'm only licensed in New Jersey. I can only give you advice in New Jersey, and guessing is always wrong. For me to guess and say, yeah, your New Jersey will here will pass your assets in the Philippines or any other state, my answer is, I don't know. You have to speak to someone there. Now you always want in your will. It's your right to do with your assets what you want. Okay, and there should always be a clause that indicates that if any beneficiary passes, who gets their share. So, the traditional family will goes to spouse and then to children. If any of those children predeceased, then to their children. All right. But it is your right to do with your assets what you want. So one of my clients last year, she attended one of the seminars, and she said, do I have to treat all my children equally? And I goes, no, it's your right to do with your assets what you want. And he goes, what's your concern? He goes, well, I have 4 kids, but one of them lives on the West Coast and we don't hear from that guy much. I goes, well, okay, let me ask you a question. Did you get a card or a call on your birthday, Christmas, or Mother's Day? And she goes, no, we don't hear from him much. I goes, why would you leave this bum anything? If he doesn't care enough about you to acknowledge that you're alive, why would you leave anything to him? So that's why we want to have a clause that says nothing to X person. So that brings us into the subject of what's called specific bequests. Now, what a specific bequest is, it's where, sometimes, for example, some people may give a specific amount of money to a charity that is special to them. So some people might say, I want to leave some money to St. Cecilia's Church. Someone might say, I'm going to leave a bequest to the South Brunswick Friends of the Library. It has to be a 501c3 charity. Someone say, I want to leave some money to the any kind of charity. Okay. Sometimes the ladies want to leave jewelry to their granddaughter. That's fine. Sometimes the gentlemen were sportsmen and they have hunting rifles that, for firearms, it has to go to someone that has a permit. So if you have some specifics, you can type that up. And if it's stuff of a value, the stuff in the house typically has no value at all. The furniture, whatever. But if you want someone not to get the money, you just nothing to name a person and their children. You don't leave them $1 because then you don't want to have them involved with the estate and not cashing it. Also, you want to have clauses that say someone who is a young person doesn't get money outright. So typically when people have minor children, we have what's called a testamentary trust within the will that says that, okay, they get some when they're 22, some when they're 25, the balance when they're 30, but the executor can expend as much money as they deem appropriate to pay for college, education, support, emergency, huge emergency medical bills, so it's the trust. On the other hand, if someone drops out of college and says, hey, Uncle Bob, I need $100,000 to go on a trip with my friends, the answer is no, your parents didn't work hard so that you can goof off. So one of a big reason when you have minor children having a will, even if you don't have much, is so that the kid, if there's no will, those kids get the money the day they turn 18. And, every single kid in South Brunswick High School, as big as it is going to know so-and-so is getting $500,000. So it's also important that if you have minor children, you don't want to name your minor children as beneficiaries on life insurance or beneficiaries on any of your, IRA, 401k, etc. Instead, you want to make it my estate so that they're not getting the money outright. when they turn 18. That is important. Just think, what would a 19-year-old do with money? Let's say if I would have got money when I was 19, I would have bought a red fast car, and I would have went to Seaside with my friends, and they would have bought beers. So the idea is you have to look, an attorney can help you, kind of plan, prepare, and you got to think about what are some of the things that would, could happen. So a guardian is the person that will watch over your children if something happens to both parents. They don't have to live in the U.S. But sometimes someone says, my client goes, I have no one in the U.S. And, they're all like, they're back in India. Okay, well, that's the only person there. What some people will do, though, it's they will have someone as a trustee in New Jersey. I mean, as an executor in New Jersey, but they can still have a family member as the person who is the the guardian of kids, trustees, and somewhere else. So think about trustee holds the money, guardian holds the kids. So I don't, it's a difficult thing for some people to think about when they're minor children. He goes, no, it's pretty easy. Okay, if you couldn't come home for the next week, who would you trust watching your kids? Let's say, and who don't you want? Because it was funny when my wife and I had our first child. We were redoing the will, and we go, okay, who's should be the guardian? Because first she says, how about my mom? He goes, your mom. Your mom's good to watch the baby for a couple of hours, but she'd be bringing the kid to church every day. And the kid, then my wife goes, well, how about your brother Steve? I goes, my brother Steve, he's single. He couldn't raise a kid. He goes, frankly, I don't know if I could at the time. So interestingly, our first guardians were my parents. And then then my sister got married. Then it was my sister because she was here. When my sister moved to another state, we put back my parents, because even though people were getting older, who's gonna be kind of like that would look after your kids. Now, if you're writing anything down, write down. Make sure you have a self-proving will. Make sure you have a self-proving will. Under the old law, the person signed the two witnesses, but then the executor would have to locate one of the two witnesses to have them sign a certification saying that they watched the person sign. And I remember when grandma passed, and we finally located one of the witnesses, because it was in Bergen County. And she goes, yeah, I was a witness there. My fee is $500. And we said, we're not paying you $500. She goes, okay, then get the other witness. Well, she's dead. He goes, yeah, my fee's $500. Well, if we didn't pay her the $500, we would have had to spend thousands of dollars filing a complaint order show cause to have the will admitted that it was done the old way. So the new way with self-proving will is person signs, then there's two witnesses, then the attorney notary signs, then the person signs again, two witnesses, then the attorney or notary, what's called self-proving language. And that's important because that way the executor doesn't have to locate any of the witnesses. But importantly, these be careful of cheap things online, because they're typically not self-proving wills. And you haven't saved money, because down the road they would have to, you'd have to find witnesses. Now, I mentioned only have an executor one, executor two, and don't put things off. Let's say, don't be a putter offer. You don't need to read anything. Well, there was a gentleman that, he was a retired engineer, but he goes, I said, okay, we should do this, this, and this. And he goes, well, I want to read more up on it. I go, sir, you don't need to read up anything. I went to law school. I passed the bar. I went to many seminars. I give the seminars. I wrote a book for the American Bar Association. I read for you. I said, when I had knee surgery, I didn't read up anything at all about knee surgery. I just called Rutgers Track Coach. Hey, who's the best guy you could send me for knees that's around here? And so anyway, the engineer that wanted to read up, 2 years later, his daughter calls up. Oh, Mr. K, my dad passed. Do you have his will? Because, we found like your business card and some communications. He goes, no, he wanted to read more up on it. And we kept on following up. And, so again, You don't need to read up on anything. Get the things, get things done. Now, my mother-in-law used to call me up every other year and say, I want to get a trust done. I want to get a trust done. And I would say, were you watching Susie Orman on TV? And she would say, oh, yes. I goes, well, Susie Orman is exactly right. If you live in New York, California, Florida, where the probate process is very, very, very complicated, very complicated. But New Jersey's the probate easiest state. Let's say, also, a couple, came in yesterday, like mom had passed. I go, okay, I'm going to fax over to the surrogate, the will, the death certificate, this like 1-page form. And then you get to call them up tomorrow. And then you get to drive to the surrogate's office with the original will, original death certificate, and a check for $160. They're going to give you the papers to sign, and you're going to leave with this. How difficult is that? I mean, you do have to wait 10 days after someone passes, but anyone who says, I want to get a trust done, he goes, why do you want to spend between $3,000 and $7,000 having trust done? Because just to avoid the $150 in probate. Again, it's different in other states because Florida takes 2 years, it costs $15,000. But in New Jersey, because probate is easy and expensive, I ask people, why do you need to spend that money having a revocable trust? Number two, a revocable trust does not protect assets from nursing home or taxes. Sometimes the trust salesmen talk about, oh, a trust is private, but a will is like, a public record. It goes, yeah, but what do you care if people know that your kids are getting your assets? And number two, if you're doing a revocable trust with your house, you have to have it, 5 documents filed with the county: a new deed, the seller's residency certification, the affidavit of consideration, the check, and the cover sheet. So you're looking at paying like more money. And I ask people, why do you think you really need a trust? Not relying upon what your friends in another state may have said to you. Now, those are revocable trusts. Some people want to protect their assets in the event they have to go into a nursing home, and those are called irrevocable Medicaid trusts. But so a couple of things with that. The attorneys that do that, because it's such a specialized field, often charge $15,000 to do it. I mean, it costs $15,000 a month for Medicaid. So if they save assets, there's a 5-year look back period. You can't be the sole trustee, and you can't undo what you've done. So I told people, before they make anything in irrevocable trust, think hard and fast on what you want to do, because once you do it. But on the other hand, sometimes a trust is better sometimes than just giving stuff away. Because if you just give it away, you've given it away. And a giveaway is a gift. You can't undo a gift. I've been in court, wasn't my case, but mom signs her house over to the daughter. She's living with the daughter, and then the daughter gets remarried, and the new husband, after a while, says to his wife, hey, you got to get rid of the old lady. She's driving me crazy. And the daughter says, Mom, you got to get out. This is our house now. And the judge said, listen, this is horrible, but my hands are tied. You made a gift. And another matter, like, the fellow should have did a trust, but instead he gave half of his assets to son, half to the daughter, had a new deed done, half to the daughter, half to the son. He goes, okay, now I just got to keep my hand and my fingers crossed for 5 years. I don't go into a nursing home. Well, the son dies. So who now owns half of everything he has? His daughter-in-law, his ex-daughter-in-law, who could safely gift it to her new husband. Now, me, on the other hand, when people says, what do? I goes, nah, I'm just leaving everything. I don't care. I'm not looking to, quote, make myself penniless to qualify for Medicaid. Medicaid, who pays for nursing home? Either you pay for it or welfare pays for it. Okay. And you don't want welfare. You don't want to be in the welfare nursing home. And me, I go, listen, I worked so hard for my money over the years. So hard. I was a paper boy, so anyone that was a paper boy knows about getting up early and delivering newspapers in the rain and having to collect money. And then, I was cutting. I was always working hard, working at fast food places. So I go, hey, why should I go into the dirty nursing home so my son, Dr. Brendan Vercammen, can have a bigger boat? Let's say, So that's my little bit. And by the way, many people nowadays have like through their companies have like what's called like prepaid legal plans that cover payments of will. So I put in the chat box, like one of the biggest ones in New Jersey is the MetLife Hyatt legal plan that covers different companies, and some like Johnson and Johnson, some other companies, have one is called ARAG, the other is called Legalese. Some of the retired auto workers have that, and I put that in the chat button. So for the people that have those kind of plans, I was talking to a gentleman tonight, and he goes, I go, okay, you have a 7-year-old and you get a $1,500 worth of documents for free. What are you waiting for? Let's say, get it done now, get it done now, get it done now. All right. So let's say, and by the way, anyone that listens to any of our programs, I always say we'll give a free consult, because typically we charge a $200 consult. Okay. And now, by the way, I did mention the trust for minor children within the will. Sometimes we have trust for non-minor children, but we don't want them to get money. So the people that have special needs kids know that they should have a special needs trust, because if their children inherit money, they could use their government entitlements. Other people, though, have, not kids with quote special needs, but they have kids with issues. They could have a drinking problem, a substance abuse problem, or going through bankruptcy, a spendthrift. So sometimes we'll say, listen, the money for that person, I want to go into a trust within the will. And that's important, because we were hired to handle an estate where mom has a will, but one of the kids had an alcohol problem. He goes, hey, his money is going to be held by this daughter in trust to a testamentary trust where she decides where the money goes. Well, that was important, because the guy's ex-wife filed a complaint saying, I want you, court, to compel the estate and the trust to pay my alimony. And I said, Judge, the reason why people set up testamentary trusts is to protect it and have the money available for the person's support over time. That's why it's shielded from, believe it or not, taxes. It's shielded from Medicaid, these testamentary trusts. It's shielded from alimony and even child support. And the judge says, Mr. Vercammen, you have the case law. That's absolutely right. And so in that kind of testamentary trust for a grown adult, the money's used to pay for his rent, to pay for his car insurance, to buy him gift cards, but we don't, no money is given to him because he would spend it on booze. Okay. Logistically, most attorneys now, we prepare the documents, we email it to people so that they can print it at home or read it at home. And if everything is good, they have the option of either signing in our office on a Monday or Tuesday when we have witnesses, or what happens is they will, again, you get to decide, what to, if you want to do it in front of a notary. A lot of people now goes, hey, I work until 5 o'clock. I don't want to have to take half a day off of work to drive to your office in Edison. So again, having the wills is not that complicated. The next thing I want to talk about is the power of attorney. Okay. A will takes care of your assets if you pass away. Okay. What a power of attorney is, it's giving you, you're giving someone who you trust the ability to be able to pay your bills. Let's say so. A will takes care of your assets if you pass away. What the power of attorney does is you're giving instructions to everyone that, let's say, okay, if I can't sign on my behalf, my agent, who's typically the executor, can sell real estate, has access to my bank accounts, has access to my medical records under HIPAA, can sell and transfer my stocks, bonds, enter into contracts. And we even put in a clause for gift giving in the event that gifts had to be made, to try to spend down the, certain assets. Now, a power of attorney is either effective right away or only upon disability. Let's see. Now, we always recommend that it be effective right away. And the reason for that is if it's effective only upon disability, then you have to go get, proof from a doctor that someone's disabled, present it to the bank. And the banks are very difficult sometimes in dealing with these, and by the way, a few years back, some of the banks were saying, oh, it wasn't done on our, first fidelity form, so we're not going to honor it. And so New Jersey legislature came out with a statute that says if the power of attorney makes reference to the New Jersey statute, then the bank has to honor it. But the power of attorney has to make reference to Section 2 of PL 1991 C 95 C 46:2B-11. And we're pretty sure those cheap powers of attorney you find online don't have that. We also recommend that a new power of attorney be signed every 5 years. A will basically is good forever. Let's say, now you want to look at your will, periodically to make sure that the person who you picked as your executor can still do the job. And by that, I mean, let's see, can the executor go to the surrogate's office, climb up a flight of steps? Can the executor drive to a bank and do the work that's needed as an executor? I mean, it's not that complicated, but if someone is blind and doesn't drive, then they're no longer a good choice to be executor. And just like there's concerns that unrelated to estate planning. When does someone still drive when they can barely walk because they're being unsafe to themselves and to the family? And we see these crashes all the time in Monroe where people that are 90 whatever years old that need walkers, but they're driving and their reflexes are no good and they're crashing and hurting other people. So that's not really an estate planning thing, but sometimes if you're helping out mom or dad or Uncle Joe, it's something you have to think about. So trustee, can the trustee still do the job? Power of attorney, can your agent still do the job? Sometimes people do documents where they pick someone who's a friend of theirs, a really close friend. They did everything together, but that close friend is no longer around in New Jersey. They don't have to be in New Jersey, but I look at the people that were at my wedding 33 years ago, and aside from family, have I seen any of the great friends, years? I mean, my best man's in Central Florida, and another guy's in Boston, and this person's here, this person's there. Look to see, not only can your executor still do it, but would they want to do it? Let's say now, and on the other hand, if you're the executor of a will, before you rush off and bring the will to have the will brought to the surrogate's office, are there assets in the estate, or is it a bankrupt estate? Sometimes you have to look. Sometimes someone could only have bank accounts, but Medicaid, a person was in a nursing home or a hospital, and Medicaid's owed $100,000. Well, you don't want to be getting involved in a state where the debt is $90,000 and the assets are, only $89,000. Now, but a will does not have to be updated if your beneficiaries and your executors remain the same. But you got to look at your old documents. Okay. Now, with the power of attorney, it's worth the money to have an attorney do it right, but you want to have it done now again, because while you're well, or while someone else is well, every week we get a call. Oh, I have to come and get power of attorney over mom, dad, or Uncle Joe. Well, you can't get power of attorney over anyone. they have to affirmatively, you know, you know, you know, express that you're going to get it. And when we're talking to someone, even, sometimes, people are hospitalized there, or they could be temporarily in a facility, and we're trying to help our families, but we need to talk. I need to talk to them. Okay. And if someone can't communicate to me that, they want this child as number one of the power of attorney, and this person is number two, then we can't do it. So you can't get power of attorney over someone. Now, the only other option is spending thousands of dollars going through a court guardianship, having the Superior Court declare the person incapacitated. It used to be called incompetent. And it's a very sad procedure, where you're, having to have doctors certify that your loved one, your parents, whatever, is no longer has capacity. It's very sad, and it's very expensive. Plan on spending at least $4,000 between the court fees and the court ordered attorneys and experts. So, the idea of having a power of attorney is you're saving the family thousands of dollars and the stress, let's say, of that. So, have a power of attorney done. Next document is the Living Will Advance Directive, medical proxy. It's easier for me just to say the word living will because it flows better. People remember about 10 years ago, the Terry Schiavo case, where the lady was declared brain dead, and her husband went to the court saying, listen, I want you to remove the life support. And then her parents hired attorneys to fight it and say, no, we want her to be kept alive because her eye, we spoke to her and her eyes moved, and she knows she's signaling us. And the doctors at the hospital says, no, she's brain dead. That's an involuntary contraction, almost like breathing or twitching. But so it goes to the Supreme Court, spending hundreds of thousands of dollars. And the Supreme Court said, this is why that's why you should have a living will. So the Living Will Advance Directive is really not even a document for you, because you're the one, you're in a coma, irreversible condition because of some type of disease, and it's the end. And it's a document that it's to not put your family through the trauma of the doctor having to ask the question, should today be the day? So that's why the living will, is important, because I remember when a doctor asked me, should today be the day, for someone who didn't have a living will. And I mean, I was the power of attorney for the person. And what the right decision is really for someone that's 92 years old, that's not going to wake up and get out of the bed again. But you hate to be the one to say, okay, doctor, yeah, end the person's life today. I mean, I couldn't do it for my dog. When my dog was so sick, I had to have my wife go into the vet. He goes, you're going to have to go in, because otherwise I'm going to bring the dog back home and spend another $16,000. So now with the Living Will Advance Directive, there's different sections. And we took language from the State Medical Society, that way doctors were familiar with it. So the first section deals with fluids and nutrition. And the 85-90% of people say, listen, if there's no hope for me and I can't talk and I'm not going to get out of the bed, I don't want any fluids and nutrition, which is like feeding tubes. I used to say, if I couldn't run every day, I want to be put down like to do the racehorses that break their leg. But then the first time that I was in on crutches and with a leg boot on, I goes, all right, don't put me down yet. I still got some good years. The next section of the Living Will Advance Directive deals with medical treatment, artificial machines. And 99% of people say, listen, if there's no hope for me, I don't want machines, keeping me alive. Now, also in a living will, you typically want to have a durable power of attorney within that for medical decisions. And it can be someone different than the person in your regular financial power of attorney, because sometimes someone says, listen, this person is better with money, but this family member, this daughter is a nurse and she's more familiar with the lingo. And that's also important because, if you were so sick that you're in the hospital and, you can't talk, what was happening sometimes is the kid that wasn't around, that wasn't helping out, that wasn't making sure you're okay, all of a sudden they drive out to the hospital, they barge into the room, it's okay, I'm in charge now. I'm to make the decision. Because, well, you have a living will and says, no, 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 you don't make any decisions. The decisions are made by this other person. And, in a way, the living will is a very important document for someone who is not married. And before they, especially before they legalized same-sex marriages, it was important for me to do this because, if someone was in a hospital and they couldn't talk, a parent could come in and say, "Hey, get this person out of the room. They have no right to be here because they're not family." The power of attorney, in a way, the power of attorney is more important than a will for someone who's married because, hey, if you're married and the kids are from the same relationship, the spouse gets it otherwise. But if you don't have a power of attorney, a spouse has no right to do anything. However, let's say someone's getting separated. Let's say, well, rush out, and get a new power of attorney done right away and a new living will done right away because you do not want to have that person, who you're going to be Xing from to be making decisions. They're going to say, yeah, kill him off now. So it's an important having a living will is important and making sure the person there is good. So, if someone in the family is like, sometimes getting unmarried, have a new one done. Also in the living will, we usually have a clause, organ donation yes or organ donation no. And I was very surprised. I went to a seminar put on by the NJ Sharing Network, which the NJ Sharing Network is the entity in New Jersey that deals with organ donation. And I said, but I go, what's the maximum age to be an organ donor? They go, there is no maximum age. I goes, well, what's good on a 85-year-old guy? They go, skin and cornea. And I goes, you know what? I never thought about that. If I couldn't see, I'd take the old guy's eyes. If I was burned in a fire, I'd rather have the old guy's skin than what was burned off of me. And I also asked, what are the medical conditions that disqualify you? Because to be a blood donor, the list is 8.5 pages long. And at the time, the only disqualifier to be an organ donor was HIV positive. And that was changed because someone who's HIV positive can give be an organ donor to someone else that's HIV positive. So if someone wanted to donate a kidney to a partner, they're allowed to do that. Sometimes someone has someone that it's a second marriage, or it's a their significant other that says, listen, I don't want to have them kicked out of the house the week after I pass away. So I'm giving a life estate or a period of time in which so-and-so can stay in the house as long as they take care of all of the expenses. Okay, let me talk a little bit about probate in New Jersey and how easy probate in New Jersey is. So, just like with the wills, we email everyone a short questionnaire before they come in because most people want to come in and go over things. And I goes, yeah, that's it's more comfortable where someone comes in and people are under stress. But we type up the surrogate. Each county surrogate has their information sheet. We send them the will, a death certificate, the information sheet, and then the clients go there and they don't need to spend money having the attorney go with them. Once the person becomes the executor, there's a thing called the notice of probate. It's a form that we send to everyone who's a beneficiary in the will. And also we have to send a notice to everyone that would have been inherited if there is no will, because under the law, they're given 4 months from the date of the notice of probate in which to challenge. All right. Then logistically, for most people, I say, listen, the more things the executor does, they don't need to pay the attorney to do. There's a house. Most of you can tell the other beneficiaries, if you want the stuff in the house, the microwave, the couches, but otherwise people hire the 1-800 type junk companies. And the attorney will prepare what's called an inheritance tax return. Now, I mentioned there's no inheritance tax in New Jersey, but there is if there's going to spouse children, but we still need to file the inheritance tax return so we can get a waiver on assets. If there is a tax due, you can't get the assets until you receive the waiver. And the sooner we file it, the better, because even if there's no tax due, it's taken Trenton 3 months, 4 months to respond. If there is tax due, 13 months or more. So we want to get online and file right away. I'd say it's a good idea for the executors to send an email to the beneficiaries every 3 weeks, just to give them a little, BCC, but to give them a little, update. This is what's going on, because the frustrating thing is when someone doesn't hear anything and they don't know if the person left the country and went somewhere else. Once the executor typically will obtain a tax ID number, the attorney can help set up an estate account. That way the money goes in there. Everything's paid through the estate account. At the end, the executor prepares an informal accounting, and the attorney prepares a document called a release and refunding bond. It's a paper that the beneficiaries said, okay, I'm getting approximately this amount. I'm satisfied with the executor, and therefore I am going to be, has to be signed in front of notary. If all the beneficiaries don't sign it though, then the estate has to go through a very expensive complaint order show cause for a formal accounting. Very, very expensive. So when in the estates where someone hasn't signed the release and refunding bond, typically we send a letter out saying, we can't do anything until this person signs. Everyone else did sign, and that there should be if that person signs, everyone get their money in the next month. If they don't sign, they get their money in another year. And by the way, the person didn't sign, their name is this, their address is this is their phone number, this is their email, so the family can encourage them to sign. Lastly, this is not a legal document. It's a good idea to prepare what's called a letter of instruction. On my website, njlaws.com, we have a form letter of instruction. It's something where you can just type up, hey, this, if I'm the pass, do you want a funeral, not a funeral? Do you want to have a wake? This is who should be notified. You're advising where your stuff is, and who your important people are, who's your accountant, etc. It helps the executor out immensely. And with that, what's my name? My name is Ken Vercammen, and I'm a local attorney, and hopefully you can talk to us. Get your documents done. I just put my email in the chat button, and my phone number is 732-572-0500. And Ken Vercammen is finished speaking now. Now I'd like to have my colleague Dan Fabrizio talk for a little while about some of the mistakes that he sees some people make as a financial advisor.
Good evening. Thank you, Ken. Hello, everyone. My name's Dan Fabrizio. I'm a licensed registered rep with New York Life and Nightlife Securities. I worked on Wall Street for 22 years, where institutional investors were my clients. And now I work on Main Street, where individuals like yourselves are my client. I'm licensed in the state of New Jersey, New York, Pennsylvania, and now Delaware. And very briefly, I'm not going to be very long, but I just want to touch on some of the 7 common retirement mistakes as one is in retirement or nears retirement. Number 1, not planning your retirement with your life expectancy in mind. You got to stop using your parents and your grandparents as your estimates for your life expectancy. The reality is that life expectancies are increasing more than they were 30 years ago due to modern technology and medicines. So the important part is to rely on the data much more than, say, your parents and your grandparents' age. Number 2, not being smart about claiming Social Security correctly. Some people are still taking Social Security before the full retirement age. This means that if you apply for Social Security before the age of 65, you're receiving a smaller check for the rest of your life. If you have the financial resources and you believe that you'll live longer than average, generally speaking, waiting to take Social Security at a later age means you're going to receive a larger check for the rest of your life, and that can be 30, over 30% more than collecting Social Security at age 65 versus age 70. Number three, taking a lump sum from a pension could lead to expensive mistakes. But thanks to lifetime annuities, it can help retirees meet their retirement goals with a guaranteed lifetime income stream when a lump sum payment is your only option. If you're able to receive a pension, say if you work for the state or the government, that is by the best way to go. But there are some people who just have a lump sum check and don't know how to spend it and not sure how long it's going to last. Lifetime income annuities can make that check last your lifetime as well as your wife's lifetime. Number four, too much risk in your investment as one nears retirement. By taking more risk with your portfolio when you may not need to, can dampen or reduce the retirement income that you need to live on. For example, I have friends that were in their mid-60s getting ready to retire about a year and a half ago. And then all of a sudden, 2022 hit, and their investments went from a 401k to a 201k. They just had too much equities in their portfolio. The best way to go is go cash nowadays, maybe some conservative bonds and target funds. Either way, I just look at people's portfolios. I give them free advice on how their allocation should be to be more of a conservative risk profile. Number five, buying life insurance as an employee benefit. While it's generally less expensive and easy to take the group term life insurance when you're with your employer and still worker, that coverage goes away when you leave your job, whether you're terminated, whether you're laid off, whether you retire. You lose that life insurance. So if you're 50 and older, and when you retire, it can get expensive to buy life insurance. The one option, and it's not too late, is to buy permanent life insurance when one is younger, in addition to the work insurance. I have a lot of people who say, well, I don't know how my job is going to be. So they get a policy outside of their work policy. But if you're 50 and older, there are still some whole life products available that can help you with some coverage. Number six, focusing on assets over income. One mistake I've seen is failing to switch the mindset from retirement savings to retirement spending when nearing or when you're at retirement. The main purpose of saving for retirement is so that you have enough money to spend while you're in retirement. Say you have $500,000 in your IRA, but in general terms of standard living, what exactly does that mean? Based on your spending needs and other income sources, how should your assets be allocated once you retire? Can you safely withdraw 3%, 4%, 5% a year and have it last your lifetime? Here's the reality. It's hard to know exactly what kind of standard of one's living can have if all your assets are in one type of product or account. Consider reviewing your situations with financial professionals that can help you put your retirement goals and plans together. And finally, bank CDs. Older adults, when they retire, tend to store large amounts of money into bank CDs because the banks recommend it. The downside of bank CDs is that you're locking up your money in a long-term CD, and at the end of each year, the bank's going to send you a 1099 form for the interest you earn that you're going to pay taxes on, but you can't spend that interest. A better option, or an alternative option, I like to say, is if you're going to lock money up for a few years, think about a multi-year annuity instead. And here's why. Number one, you're probably going to get a higher interest rate. And the most important feature, number two, is the interest you earn is tax deferred. As long as your interest stays within the annuity, forever how long it may be, you'll never get a 1099 on it. Okay, so you're really deferring the taxes on that income. You only take money on it you only pay taxes on that interest is when you take the money out and roll it over. Anyhow, again, my name is Dan Fabrizio. I'm a financial advisor with New York Life. I'll put my name and phone number in the chat here. If anyone has any questions, I'm more than happy to answer any questions.
Okay. Ken Vercammen's back. Can you hear me? Okay. So one of the questions is dealing with in the event that someone's spouse passes, would it be advantageous to put a child's name on a deed? And I usually say no, because if you put them on the deed and then there's a falling out, they can force you out of the house and force it to be sold. Also, if your child passes, then you can just do that. So, and you're not by just putting a child on, you're not protecting it from anything. Number two, does a trust protect you from probate? Well, there's no reason to avoid the $150 probate fee. If someone spends big money, then they can have these trusts set up. But I always ask someone, why do they think they need to have a trust? Now, it's okay to put down someone as a bank account on, a kid, if they want that person to get the money. But if you put a child as like, joint with you on a bank account or POD, they get that money outright. It doesn't go under the will. And if there's more than one kid, they can conceivably just say that's just that one person. And this happens very common where someone says, oh, I put, I know my daughter will do the right thing. I goes, I know she'll do the right thing too while you're alive. She's not going to, call you up and say, oh, by the way, after you die, I'm keeping all the money in the accounts and I'm not going to share it with the other two. However, a lot of times after the mom passes, then the husband of, the daughter goes, no, that's our money. That's it, which it is. And those are all the questions. So thank you, South Brunswick Library. Any director, any last things to say?
I just want to thank you and Dan both so much for all of your time tonight and sharing all this great information. Thank you everyone else for attending. Ken, I hope we'll have you back again sometime soon.
Yeah, we're going to do it live. And actually, I just thought about something. I'm not sure if you want to promote a competing program, but
Sure.
Cranberry Library is going to be doing a live. And I only did it because I used to be the Cranberry prosecutor. And they're trying to tout their brandy new library. That's March 30th. But other than that, don't put stuff off. I get calls. Oh, well, when's your next seminar I want to go to? He goes, don't go to any seminars. Go hire a lawyer to get your will done, whether it's me or someone else. I gave a talk to the seniors in Jackson. None of them are going to come drive up to Edison and do anything. I says, I'm here to educate you, get your stuff done. And with that, everyone have a good evening. Bye-bye.
All right, thank you again. Someone asked about the video. We'll be putting the video on our library Facebook page and also on our YouTube channel. It'll probably take about a day or two to get there, but look for it and you'll be able to watch the whole presentation. Thank you again, both of you gentlemen. Have a wonderful evening, everyone.
Thanks for having us. Have a good evening.